Hello, everyone. Welcome to the Chapter 3 of International Commercial Arbitration. Today, we will cover the content of arbitration agreements and how it is being enforced or applied. The discussion includes the general concept of arbitration agreements, the types of arbitration, how to create an enforceable agreement, and we're going to talk about also the advantage and disadvantage of arbitration agreements. And lastly, let us discuss one by one the content of arbitration agreement. We have three objectives for this chapter. Number one is let us try to understand the arbitration agreement and its requirements. Secondly, you are going to familiarize the different aspects and the advantage and disadvantage of using institutional arbitration and ad hoc arbitration. And lastly, our objective is for you to identify and understand how agreement is being reinforced, including the particular parts and what are the contents of that agreement. Every design of arbitration agreement is depending on the institution or legal counsel that both party wants to adopt. Take note, whatever is written in the arbitration agreement should has a consent or agreed upon by both buyer or seller, okay? Or in the contract, we call them party, okay? So an arbitration agreement can be as simple as provision in contract stating by signing that contract you are agreeing to arbitration in the case of any future disputes. In general concept, arbitration agreement is a written contract in which buyer and seller or parties agree to settle a dispute outside of the court. Both parties have the privilege to use any arbitration process according to their preferences and accessibility to the institution. Okay, you will notice also that in arbitration agreements, okay, the party who are complaining for a particular dispute, we call them claimant. And a party who had done the offense, okay, against another party, we call it respondents. Business owner can protect their business transaction by asking buyer or seller or the counterpart in business to sign an agreement to lessen the burden of dispute caused in the future. Remember, in the contract of goods and sales, there's a particular clause or conditions pertaining to resolving disputes. Arbitration agreement is a separate document stating how buyer or seller and seller can resolve the dispute. Again, contract of goods and sale is a document, a written document that binds the buyer and the seller in business transaction, like buying or selling of goods. While arbitration agreement, okay, it pertains to a particular procedure on how they are going to resolve the dispute. Arbitration agreement condition, okay, it must be included in contract of goods and sale. Not all of the content, but a provision that in contract of goods and sale, a provision that in case there will be a future dispute between buyer or seller or both party, there will be a particular arbitration procedures to be done either litigation or arbitration. Okay, in choosing the method of arbitration, both party, okay, could decide which type of arbitration they're going to apply with their transaction, either institution or ad hoc types of arbitration. If a party had decided to choose institutional arbitration, okay, they are going to follow a set of rules and guidelines coming from a different institution, okay, like International Court of Arbitration, London Court of International Arbitration, and American Arbitration Association. There's a lot. Every country has a particular institution that promotes and handle this kind of arbitration. Okay, but remember, each institution has its own set of rules, which provide framework for the arbitration and own form of administration to assist process. Okay, so if you decided to choose ICC, okay, you have to comply with the rules and regulation of ICC, and I think they are going to administer the arbitration process. Okay, they're going to organize the place. They're going to set the rules. They're going to give you the requirements, okay, that you need to comply for the proceedings or for the hearing of a dispute to be resolved. Okay, what are the reasons why some of the company or parties had chosen to use institutional arbitration? Number one, there is an efficient conduct of an arbitration through enforceable award. Okay, because institutional arbitration, there's an available pre-established rules and procedures which ensure that the process begins in timely manner. Most of the institution like AAA, they provide an administrative assistance or secretary. Okay, they could provide you also a list of qualified arbitrators to choose from, which, okay, could give you a reason not to doubt the award, okay, or uh, this could be a factor that institutional arbitration can provide unbiased award or impartial apparatus. In addition, the institutional arbitration could help in the commencement of an arbitration since they already established the formats and with a proven record, it could save time for both parties to resolve the dispute. This institution already knew how they could be able to enforce or implement the award. Okay, so for a party who is claimant, okay, it could guarantee that his claim, as much as possible, if it is proven right, okay, there is a guarantee that his claim or their claim will be granted. But on the other hand, institutional arbitration can be expensive because of additional expenses like arbitrators' fees, venue, and institutional membership. Of course, you need to spend for money and transportation. Okay? And the worst case is that the cost is more than the actual amount in disputes. One disadvantage also is what we call the bureaucracy from within institution. It means that the decision of the arbitrator or the award might be influenced, okay, by some political figure or some corporate personality. So that could be one of the disadvantage. But if your evidences are strong enough, okay, there's no way that you're gonna lose in this kind of arbitration. But remember, arbitration's objective is to put buyer or seller or both party in a win-win situation. Okay, next, why some parties decided to choose ad hoc arbitration. Okay, so this kind of arbitration, which is not administered or controlled by ICC, LCIA, DIAC, or DFC. Okay, so both parties have set up their own rules for arbitration. Okay, and they can decide how many arbitrators, which kind of applicable law they want to use, and the place to conduct the arbitration. They can spell out the discovery and scope of obligations and set limits for arbitration. They can use ancestral arbitration rules. They can modify that to suit for their purpose. Okay, the efficiency and effectivity of the ad hoc depends on the proper structure of arbitration rules, and it depends also on the cooperation of both parties. Nevertheless, the burden of ad hoc is in the arbitrator, for he or she will organize everything about solving the dispute. Is going to set the rules, going to set up the room, going to choose for the right arbitrator, or he's going to choose the right guidelines to use in resolving a dispute. After choosing the right type of arbitration, either institutional or ad hoc, okay, let us now understand how to create an enforceable arbitration agreement. How can we apply and use the arbitration agreement? Okay, compliance with arbitration agreement requires some considerations to effectively implement the conditions written in the contract, like making the agreements easily to read and understand. Provisions must align with the original contract of goods and sales, and it should complement with state laws or domestic laws. Remember, arbitration agreement is an agreement that will guide both party to resolve dispute, not to worsen the dispute. That's why, as much as possible, the written arbitration agreement must be systematically, technical wise, okay? It should be organized and easy to understand. By entering into an arbitration agreement, the parties commit to submit certain matters for the agreement to be enforced. And here are some of the considerations of implementing an enforceable agreement. First, it must rise out of mutual concern, meaning in order to be valid and enforceable, arbitration agreement must agreed upon by both parties. Secondly, the parties must have legal capacity. It should be represented by legal persons or authority to build the agreement. It also means that the both party are binded by legal document or the contract is signed. Okay, they're going to execute the arbitration agreement if the contract is valid, meaning if the contract of good and sale is being signed by authority, like if it is being signed by a public attorney or a lawyer, and it has a witness. That is what we mean by checking the legal capacity. Of course, if I'm an arbitrator, I should check it first. I'm not going to spend my time and effort without any legal basis of proceeding with the arbitration uh, process. So I have to check if both buyer or seller came to my office and they have a legal document stating that we have a dispute. So our dispute has a basis. We have a contract and our contract is legal. And that is what we mean by checking the legal capacity of the agreement. Third, it must be made in writing. There must be a legal document as I had mentioned. Okay, it must be signed by a lawyer and it has a witness, okay? Because that could be a basis. And in arbitration, we do not honor a verbal agreement. It should be noted through written documents. And lastly, arbitration agreement must define legal relationship. Again, it must be the contract must be binded, signed by public attorney or lawyer, and both party is legally represented. They don't have any particular issue with legal matters, or they don't have a state of immunity. We have to check if both parties has the capacity to accept the award or legally binded, or they don't have any waiver like state of immunity. So we have to check the legal relationship. They don't have no bad records, or they don't have a criminal records. And that is some of the considerations in enforcing arbitration agreement. Again, every institution, every rules and regulations, they have particular considerations on implementing the arbitration agreement. What are the common practice in implementing arbitration agreement? Number one, it is normally separated from contract of sales. It is not the contract of sales itself. It is a separate document containing the terms and conditions on how the dispute is going to solve. In the contract of goods and in sales, there is a particular portion or clause pertaining to how they're going to use arbitration, what kind of conflict resolution they're going to use, either arbitration or litigation. So it also must express arbitration agreement in contract. Arbitration agreement is designed, okay, to complement the contract of goods and sale, not to negate, not to oppose, not to change the consent of the contract. Okay, again, it is only intended to resolve dispute. Normally, it is reduced in writing. Okay? It composed of 1 to 2 pages. Okay? Not unlike the contract of goods and sale, it details the every transaction of the buyer and the seller. What are the advantages and disadvantages of arbitration agreement? What are the positive and negative effects of arbitration agreement in solving disputes? Let us discuss them one by one. Availability of arbitration agreement can resolve dispute in faster and less expensive way because the guidelines and process are already determined and planned, and that could be the first advantage of arbitration agreement. Secondly, that both party can choose arbitration without bias and can protect from influencing the decisions of arbitrator. Okay? The third one is that arbitration agreement generally held in private and both parties can agree to keep the final solution confidential. This is especially appealing if the subject matter of the dispute involves private or embarrassing information. Lastly, both parties can preserve and have the ability to protect their business relationship because of mutual understanding, and they would give some considerations to the conclusion to the dispute. The solution might be taken light because of the informality of proceedings and the personal relationship of buyer to seller or vice versa. On the other hand, arbitration agreement has disadvantages for both parties. Okay. First, arbitration awards cannot be appealed. The general and practical rule is that arbitration's final decision cannot be appealed because normally decisions are agreed or consented by both parties with careful discussion. It can be appealed if one party resists the award, and it can proceed to higher court or litigations. Okay, it means that it can be appealed if they found out or they think that the award is not equal, or the award is not good. That's the time they can proceed to the higher court. Secondly is the limitation of the parties' exchange of information, because lack of necessary information to evaluate the case could brought some biased decisions. The possibility also of providing evidences, K, could hurdle good decisions or award of arbitration. Okay. Again, presentation of limited information can lead to inadequate basis of the award. Third and fourth, you cannot have a jury trial, and it is prone to unfair trial. Since it is done in informal setting, it waives the privilege to be evaluated by legal counselor, and arbitrator may take or his decision without issuing any written or explanatory statement, because arbitrator is not legally binded. Okay, so because both party agreed to choose that arbitrator, therefore they are only covered by a certain rules and regulations. Okay, so of course, considering the government law, it must not be affected. Once it is being affected or violated, therein the government intervention will take place. Okay, now let's move on with the consent of arbitration agreement. Take note, this is the basic or standard consent of arbitration agreement. The content and format depends on the type of arbitration that both parties had agreed upon. If they use institutional or ad hoc, uh, they're going to follow the rules and regulations and the consent of the template of arbitration agreement, because ICC, AAA, Uncitral, LCIA, they have a different format of arbitration agreement. First is the scope of arbitration. On this part, it states, okay, you will read in this part, uh, the damage, the nature of damage, the nature of claims, the nature of dispute. It also explains, okay, the purpose of arbitration, the nature of disputes, and how the process will be done. That could be the scope or the extent of the dispute. Next is some of the content of arbitration agreement is particularly they write if they're going to use institutional or ad hoc. Third is the number of arbitrators. Okay, generally, both party can choose one or three arbitrators. Okay, you have to consider that because the more arbitrators you are going to choose, the more expenses that it may incur, or you're going to pay more arbitrators fee. Number four is the seat of arbitration. When you say seat of arbitration, it is related to the place and rules and procedures of the arbitration. Where will be the hearing or proceedings may take place. Next is the applicable law. Okay, so this is about which law should be followed to establish the materials of the dispute. Okay, the award is built based on the foundations of facts, making its decision fair and reasonable. And applicable law will guide arbitrators' decision making. Okay, in general, the ruling to be followed is where the dispute happened. So if the dispute happened in Korea for Vietnam and Thailand, and Vietnam is the claimant and Thailand is the respondent, okay, and it happened in Korea, the governing law, okay, must be that to be followed must be the Korean International Commercial Arbitration. But it's depend upon the what is written on the contract. Again, it is always the contract of goods and sale will dictate, okay, the proceedings of arbitration, especially in choosing the arbitration process. Next is the language of the arbitration, because you know it is international, so it will be coming from different country. Okay, so if both party fail to choose which language is to use, the arbitration committee is going to select, okay, what kind of language to be used. But normally, even as international, they do the arbitration proceedings in English language or the common tongue of both parties. In Article 17 of UNCITRAL, okay, for the arbitration ruling, arbitral tribunal shall determine the language of both party that comes from different countries. As I had mentioned, normally it is English. And the last one is we have the miscellaneous matter. Okay, it includes the different details of the arbitration processes. So let us discuss them specific one. Okay, the first miscellaneous matter is what we call the state immunity. Okay, why? Because there are some agreement between country to another country on waiving, okay, the jurisdiction and execution process. Okay, let's say if the party is from US, okay, and the other party is from Korea, okay, they are going to consider a bilateral agreement. Okay, so if it's not covered with the state immunity, okay, it will not be applied. Normally, the state of immunity is applicable for like diplomats, soldiers, prime ministers, okay, and the ambassadors. They are the higher ranking officials of the state. So those are the people who normally have that kind of state immunity. The second one is the security for claim. Arbitration agreement state the assurance on how to get the claims or how the award will be given, okay, appropriately to the claimant or the one who is complaining if the award favor the claimant. Okay, and the security for cause, it means that um, who will pay the arbitration cost. Okay, normally it is the loser. Okay, in legal terms, it is the loser who will pay all of the arbitration costs. Okay, so that is the next miscellaneous. And the last one, we have the punitive damages. Okay, if the the arbitrator, okay, consider that the claimant has the reason to complain, okay, the damage, okay, the punishment to the damage must be implemented. So that punitive damages is the damage itself that must be punished. Okay, either in monetary or or applying or implementing what the contract of goods and services is stated. We still have a, appeals on the merit. So this is the request to review the conclusion or judgment in arbitration. Again, I had mentioned a while ago that arbitration, in the matter of arbitration, you could not appeal. But unless you write in your agreement that they are allowed, okay, to review the judgment or the conclusion, okay, it will be allowed. As I told you again, that whatever conditions is written in the arbitration agreement, it must be consented or it must be allowed by both party to enforce the agreement. That is the appeals on the merits. Next is amiable composition. Okay, it means the equal solution to dispute by setting aside the rules. So in the part of arbitration agreement, amiable composition, there will be some instance or condition in the agreement that, okay, for the sake of peace, for the sake of friendship, okay, there are possibilities that they can set aside the rules. Okay, for maybe for some humanitarian reasons, they want to be kind and they found out that the respondent is a respondent really not intention to violate the contract. Okay, so there will be a possibility that they could like set aside the rules and settle for good solutions or for a more considerable solution, and that is amiable composition. And next we have the confidentiality. It is written in the agreement that any information given throughout the arbitration process must only be used inside the arbitration tribunal. Okay, whatever the award, whatever the conclusion, okay, they should keep the information private. Okay, and unlike in litigation, okay, it is a public hearing and the information can leak, okay, to the public. Here is the example of arbitration agreement. Okay, so you could see here the different inclusion. In this part, there are only 7 parts. And this is only, I think, 2 pages. The other pages is a portion wherein the parties, the witness, and the arbitrator is going to sign the agreement. So in this example, you will see 7 parts. The arbitration, okay? The second one is the procedure. Third is the arbitrator, who will be the arbitrator. And then the governing law, or whose law states, okay, will be applied in the proceeding. And then the award, okay, in the award, it is specifically stated that the parties agree to abide by any award issued by the arbitrator. That's why no need to appeal. Then number 6 is the arbitration cost. Okay, if they agreed to split, okay, by parties, okay, or otherwise determined by arbitrator. Again, if the respondent lose, then the respondent will pay the cost of the arbitration. But if the claimant lose, the claimant is going to pay for the cost of arbitration. And lastly, we have the miscellaneous. Okay, as I had mentioned, is some of the uh, legal capacity and validity that will be enforced throughout the arbitration proceedings. And you could see at the last statement, any modifications to this agreement must be writing and notarized. So this arbitration agreement, okay, can also be at the end of the procedures, it will be notarized again, signed by a lawyer or public attorney. Okay, and it will make the binding legal, because uh if the respondent or the claimant or the offender, okay, did not follow the award or did not comply with the award, definitely it could goes to the higher court, and the higher court, okay, will decide. Okay, if the higher court decide and implement the award, there's no way that the respondent or the offender, okay, will neglect or will not honor the decision of the higher court, because it is already higher court. Okay. Another example from the racket lawyer. So this format is in a sentence form. Okay. So the arbitrator shall direct the parties to file statements of their respective claims, legal submission. So more on the aspect of what are the documents to submitted, how they're going to do the proceedings, what important evidences, and how they're going to implement the award. So this one is the example of arbitration agreement. Okay. And what about arbitration clause? Arbitration clause is a particular statement, okay, in the arbitration agreement. The agreement is the whole paper itself, okay? And for the arbitration clause, it's a particular statement on how to resolve a particular dispute. Okay, so you could see here the definitions. Okay, the paragraph in a contract that requires the parties to resolve their dispute through arbitration. So this is the statement. Okay, so our specific statement that both party agree not to sue each other. Okay, it's like an oath of promise. Okay, oath of promise that a party is not going to sue, okay, one another. Instead, they're going to resolve their dispute through arbitration. Okay, so a good example here, okay, all claims and dispute arising under relating to this agreement are to be settled by binding the arbitration with arbitration resolution services. So this is example of arbitration clause, okay, and I think I got this one in the internet in the ARS, okay. So the statement says that they expressly agreed to abide by the rules of ours, okay, as found in their website at arsresolutions.com. If a party fails to pay any award, the award may be converted to judgment in the court of competent jurisdiction. This is what I am telling you. If a party will not comply or follow the award, it is automatically converted to the judgment of a Supreme Court. Okay? The reason why we are using arbitration is to minimize this kind of stress or cost, okay, of litigation, because once it is being submitted to the court or Supreme Court, okay, there's no way, okay, you could take it less seriously. Okay, it would really take or consume most of your time because you have to present evidences and you have to get a lawyer to defend your claims. So that is the example of arbitration. Okay, so I hope that you able to understand the content of arbitration agreement, okay, and how are you going to use it. Okay, the secret of this arbitration agreement is you know how to interpret that, or you could help someone to interpret the arbitration agreement. Okay, you may seek a legal counsel, or you may have a friend. It is not necessary that you get a lawyer. Okay, but okay, the secret is that you have to understand what is written in arbitration agreement. All of the content, the disadvantage and the advantage and the use of the right arbitration, the type of arbitration will help you, okay, to formulate this kind of agreement. If you choose institutional, you are just going to follow their guidelines. But of course, their service requires a cost. You need to pay for their services. But if you decided to solve the dispute in a manner of ad hoc, you may create your own rules and regulations, or you can pattern the rules and regulation of uncentral or unseated, okay, for a cost efficiency matter. Okay, so that is all about the arbitration agreement. I had included here some of the additional reading resources or references that you may want to read to furtherly understand what arbitration agreement is all about. I'm not requiring you to read all of that. That is just only an additional reading materials in case you want to validate the information or you want to gather more of the information. Okay, so I think that's for today. So if you have any further questions and clarifications for this chapter is very simple. Okay, it is only the content of the arbitration. So I hope that you learn a lot from this chapter. And for your further questions and clarification, just send me a message through my Yahoo Mail. Thank you, and this is your Professor Christine Joy Simpao, and have a nice day, everyone.